Welcome back, knowledge seekers. Today, we're delving into a topic that affects every creator and consumer alike: copyright law. Specifically, we'll be exploring its duration, its evolution over the years, and how it impacts joint works. So grab your thinking caps, because we're about to dive deep into the fascinating world of copyright. Let's start with a brief history lesson. Copyright law traces its roots back to the 18th century, where the Statute of Anne, enacted in 1710 in England, laid down the foundation for modern copyright. Initially, copyright terms were quite short, usually spanning around 14 years, with the possibility of renewal for another 14 years if the author was still alive. As time went on, copyright terms gradually extended, influenced by various factors including economic interests and technological advancements. In the United States, the Copyright Act of 1976 significantly expanded the duration of copyright protection. Works created after January 1, 1978 are typically protected for the life of the author plus 70 years. Now, let's talk about joint works. When multiple creators collaborate on a project, copyright law can get a bit tricky. In joint works, each creator owns an equal share of the copyright, unless otherwise specified in a contract. This means that all creators must agree on how to use, license, or distribute the work. But what happens when creators want to reclaim their rights? Enter the right of termination. Under certain circumstances, creators have the legal right to terminate prior grants of copyright, allowing them to regain control over their work. This provision, often found in the US Copyright Act, provides creators with a second chance to renegotiate terms or explore new opportunities. However, there's a caveat known as work-for-hire termination. When a work is created as part of employment or commissioned as a work for hire, the employer or commissioning party is considered the legal author and holds the copyright. In such cases, termination rights may not apply to the original creator, as the rights are transferred to the employer or commissioning party. Lastly, let's touch on sound recording copyright termination. Until recently, sound recordings fixed before February 15, 1972 were not covered under federal copyright law. However, the Music Modernization Act of 2018 introduced provisions for sound recording copyright termination, allowing artists and their heirs to reclaim rights to their recordings. And there you have it, folks. Copyright law is a complex but crucial aspect of the creative landscape. Understanding its history, duration, and termination rights empowers creators to protect their work and navigate the ever-changing world of intellectual property. Remember, knowledge is power. Until next time, keep creating and innovating. See you soon.